You don't often get introduced, I don't think I've ever been introduced by someone I consider a great lawyer, a great judge, a colleague in arms, as he said, and a great friend. And it's very special. Good morning, everybody. I had a mission-driven organization. We're not a service organization. We're a big mission-driven organization. The NAACP Legal Defense and Educational Fund. And I know from having talked to an awful lot of people in the last couple of years how confusing the title of the organization is to almost everybody. I was talking to some people who were working in the banking industry in New York, and they said, oh yeah, they knew we were, you know, like the Dreyfus Fund. Okay. So we're neither a fund, nor are we focused on defense. And although we were originally the legal department of the NAACP, that ended a long time ago. Since 1940, we've been an entirely separate organization. Separate boards, separate personnel, different place of work. So what is the Legal Defense Fund? Simply put, we're the country's first civil rights law firm. In today's nomenclature, we're the country's first human rights law firm. And I think we remain the country's finest human rights law firm. Thurgood Marshall was our founder. The legendary Charles Houston was the architect of our mission. And that mission, from Thurgood Marshall to right now, is literally to transform our country into the inclusive democracy it must become. And far from focusing on defense, we've always been on the offense. That's who we are. A year ago, if we'd had this conference a year ago, in the afterglow of the election and the inauguration, we would have been talking about the then strange notion that we had somehow and quite suddenly become a post-racial society. Remember that question? It was just everywhere. You know, Obama got elected and wow, on his own, that just changed everything. Today feels a long way from January 2009 and November of 2008. You know, the excitement, the anticipation, the inclusion, the generosity of those moments have been replaced by recession. We need another word, it's far more serious than a recession. Unemployment, distrust, delusionment, and even fear. We're a very racially diverse democracy, and we're nowhere near post-racial. That's our reality today, and that's been our reality from our beginning. This conference is about poverty and law and teaching law. A very important topic, especially at this time of economic anxiety and the extraordinary and growing gap between the super rich and the persistently poor, which Lauren talked about in some detail at lunch yesterday. In thinking about the issues of social and economic justice, I think we often, all of us, compare ourselves to Western European countries to see how they've been doing and then measure ourselves against how they have done. And we conclude that we come up short in comparison with Western Europe. But those countries, as I think everybody has observed, were once homogeneous or perceived themselves as being homogeneous. And that difference has enormous consequences. Homogeneity means that issues of racial difference and the attendant suspicion that come from racial difference aren't present in any calculus that you have to make about your country. In a homogeneous society, a person supports a system that offers a safety net to others because they can easily see themselves in the shoes of the others. You are literally protecting yourself. The commonality of the word "we" is taken for granted. Heterogeneity is a different reality. In our American terminology, racial diversity presents barriers to a sense of commonality. I realize when I say we're a very racially diverse democracy, sometimes I say it in a way that makes it sound like a triumph. And in fact, it's a challenge. It's a challenge on issues it's not just a challenge on issues of race. It's a greater challenge because in our society, race has always had a direct relationship with poverty, a direct relationship with alienated poverty. And in turn, this has meant that race has hindered our ability or our willingness to see and address issues of class. Race has distorted our view of the reality of poverty. Ronald Reagan's anecdote about welfare queens relied on that distortion, as did CNN's caption during the coverage of Hurricane Katrina that identified some desperate black people seeking food from a destroyed market as looters. Martin Luther King's merging of the civil rights movement with a focus on poverty was met with a war on crime. The face of crime is black men. Every one of those images is false. And the reason they resonate is due to our history of race. Drew and Payton mentioned his courageous decision striking down Prop 209. And I recall the article, I believe I saw it in the New York Times, that covered his decision striking down Prop 209. And they ran Payton's picture in that story. Okay, you know why they ran Payton's picture in that story. Western Europe is now experiencing a new and similar distortion as it becomes more racially and ethnically diverse. Distrust and suspicion of otherness has compromised the underpinning of Europe's social welfare systems. We have, at perhaps all times, been more willing to talk about poverty than to talk about race. It's a sleight of hand. To put it another way, we talk about poverty sometimes to avoid talking about race. I want to talk about both. And I know everyone at this conference wants to talk about both. We are a democracy. Democracy depends upon people being what I call peers. That doesn't mean equals, but it means people that have some equal respect about each other. It depends in the sense of commonality that I mentioned earlier. It is a critical component of a democracy actually functioning. We the people are the first three words of the Constitution, and for our democracy to be true, we the people has to include all of the people. And if you're excluded from power, banned from political participation, unable to participate in our economic life, you are not a peer in the sense that I've used the term. You're not in the common in the sense that I've used the term. And that's the issues that we have to address. With respect to black people, obviously race was used to prevent all commonality. All commonality. For much of our history, of course, black people were excluded from we the people explicitly. And democracy that existed in the United States didn't include black people in any way at all. Slaves, obviously, but don't get stuck on slaves. Free black people were also excluded. Dred Scott, Chief Justice Taney and Dred Scott was talking about free black people, not slaves. Free black people when he said that they were inferior beings who had no rights that a white man was bound to respect. No matter their education, no matter their circumstances, distrust, otherness was baked right into our culture. And if black people had no rights, they could invoke no power. The 13th Amendment ended slavery, and the 14th Amendment reversed the result in Dred Scott. Very significant. But neither addressed the issue of racial distrust and otherness. In fact, they may have exacerbated the racial distrust in white Americans for and toward black Americans. Moreover, the promises contained in the 14th Amendment went unfulfilled. Reconstruction collapsed almost as soon as it had begun. Supreme Court justices who were from the North and who had fought for the Union in the Civil War eviscerated the core of the 14th Amendment. The newly formed progressive movement turned against racial justice and any concept of equality. Separate but equal is the little phrase we know, and it supposedly describes that era. The phrase is from Plessy versus Ferguson, but the phrase was false when it was invented and never reflected reality. I'll give you one example, dramatic example. 3 years after Plessy, 1899, the Supreme Court ruled in Cumming versus Board of Education, it's a Georgia case. The court ruled that there was no constitutional problem with the Georgia School Board providing a high school for white kids and no high school at all for black kids. The more accurate phrase would be separate and degradingly unequal. There were some exceptions. There are always some exceptions. And among the notable exceptions were black lawyers. Because lawyers are an empowered profession. You know, when Kim Starr was investigating President Clinton, there was a lot of press attention to the fact that he could serve subpoenas, require the production of documents, even the most personal documents. He could ask questions of persons under oath. He could put them in jail if they didn't answer the questions. He could prosecute them if they lied under oath. And there was a lot of talk about how extraordinary his power was. Well, every lawyer in this room can do that. We are an empowered profession in exactly those ways. We can file lawsuits, we can serve discovery, we can issue subpoenas, we can compel answers under oath, and when those things are not complied with, we can seek sanctions from a court, and the court has quite unusual powers to actually make that come about. We can invoke the judicial power of the state. We can confront justice. Starting in the early years of the 20th century, there was a small trickle of black lawyers. Most struggled with marginal practices, but some of those black lawyers were spectacular and could not be marginalized. Those spectacular lawyers, along with some spectacular white lawyers, primarily at the Legal Defense Fund, used the law in collaboration with social science to confront the world of racial segregation and oppression. You know many of these cases. Missouri versus Gaines is the first in the line of cases. 1938 case, white-only law school, unconstitutional. Smith versus Allwright, white-only primary, unconstitutional. Shelley versus Kramer, white-only housing, unconstitutional. Sweat versus Painter, inferior black designated law school, unconstitutional. Brown versus Board of Education, any separate black and white schools, unconstitutional. These cases were about they weren't about vindicating existing rights. got to really think about this. These cases were not about vindicating any existing rights. Black people had no rights. Those cases were about creating new rights. And of course, this required much more than precedents because there were no precedents. There's no case that the Legal Defense Fund invoked to say this case requires that you do that because the law turned its back on racial justice. So it required an interdisciplinary approach to addressing issues of justice. Sometimes I see this described as a Brandeis brief approach to litigation. That's also incorrect. Brandeis filed his social science brief in support of social legislation, in support of legislative power. The cases leading up to and including Brown could not have been more different. They used social science and a concept of justice that challenged legislative power. It's entirely different. Racially oppressive segregation was the law, not just the custom. The Brown cases used social science and a concept of justice to create rights and protect those rights from state power. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Those are the words of the 14th Amendment. These cases brought it back to life. It was close to dead. More than that, these cases fueled a new sense of racial justice and equality. And the steady establishment of rights in those cases brought about the power to assert those rights. If you have rights, you have power. I think those cases and that spirit and that commitment are why all of us think of lawyers as social change agents. That's where that came about. Now, I want to clear something up because we see what I'm going to call a lot of loose language out there that can be misunderstood. Justice and equality are not the same thing as the rule of law. You often read it as though it is. No one fighting oppression is for some abstract rule of law, because it's not the rule of law that deserves respect. It's the rule of just law. Slavery was the law, but it was clearly not just law. Dred Scott was the law, but it clearly wasn't just law. White supremacy was the law, but it clearly wasn't just law. Nazi Germany had laws and courts and lawyers too, and it had a rule of law. The Nuremberg trials, which convicted Nazi leaders, were also about the responsibility of lawyers and judges confronted with unjust laws. Even if there are just laws, though, those laws don't enforce themselves. That requires people and lawyers committed, dedicated to just law. The Civil Rights Movement, the 1964 Civil Rights Act, the 1965 Voting Rights Act, the 1968 Fair Housing Act, and their vigorous enforcement all were consequences of that sense, that new sense of racial justice and equality. These rights are critical to being able to function as peers in our society. They are fundamental political and human rights. And we have made enormous progress and enormous gains as a democracy because of the establishment and protection of those rights. There's just absolutely no question about that. But I want to go back to the question that I just blew past at the beginning. And that's this question. It's the one I ridiculed. Are we a post-racial society? Because I can blow past it, but it still sits out there. And sometimes the question is posed with an attitude, sort of are you telling me we haven't made progress? Aren't we a post-racial society? No, we've made progress. Okay? We've made just fantastic progress. But The question is actually a different question. Are we post-racial? Felton mentioned my wife, Gabe McDougall, who is an international human rights lawyer. I did travel as her spouse to South Africa to observe the elections in 1994. She was one of the people that served on the election commission that ran the elections. And she is the UN's independent expert today, the UN's independent expert on minorities, and she goes around the world looking at countries to see how they're doing with respect to their minority populations. So we spend time talking about these issues. Here's how you go about trying to answer the question, are we a post-racial society? Do we still have issues of race? Do we have racial disparities? If you were looking at France or the United States or Colombia or pick a country, how would you go about doing that? You would look at some very important categories and then make an assessment in that country. You would look at education, you'd look at housing, you'd look at jobs, you'd look at the criminal justice system, you'd look at voting and political participation. Very interrelated categories, but I think that's the list of categories. Education, housing, jobs, criminal justice, political participation. So, let's take a look. How are we doing in education? Public education throughout the country, but especially here in California, is in complete collapse. You know, the stat yesterday that Lauren used, that California is now 47th out of 50, you know, and still falling. And education, I think, exemplifies in some way the fear and distrust that and suspicion that I was talking about earlier that comes out of race in our culture. When Brown was decided in 1954, there was an unexpected consequence. In hindsight, it seems extraordinary that it was unexpected, but I'm telling you, it was unexpected. The unexpected consequence wasn't that people said Brown's wrong, or that the president said he disagreed with Brown publicly, that's what President Eisenhower said, or that there was some violence. That was anticipated. What was unanticipated is the unbelievably dramatic white flight from the inner cities. In the 1940 census, and 1940 census is important because it's the data that's used in the housing case, Shelley, it's the data that's used in the law school case, Sweat versus Boehner. So in the 1940 census, there's no city in the United States that's majority black. Okay, not Atlanta, not Washington, D.C. Detroit, Michigan is 90% white. Gotta just think about that. Today, you know, Eminem's the last white guy in Detroit. Okay, maybe he'd love to. You know, we're so used to where things are today that you've lost the focus of what happened here. There was, in one generation, an evacuation of the cities, results in suburbs that surround the inner cities. And that change in housing patterns has had devastating consequences. It changed the tax base, it changed jobs, it resulted in us being more separated by race than we were, and it happened just like that. Most large cities have become cores of minorities surrounded by white suburbs. Every now and then you'll have a black suburb, but it'll be a black suburb. Prince George's County. And since K-12 schools draw largely on residential patterns, K-12 public schools have actually become much more racially concentrated. 2 years ago, America's Promise, that's Colin Powell's organization, issued a report on the crisis in public schools. And what they wanted to figure out was the dropout rate. You would think that it's really easy to know what the dropout rate is. It turns out it's very difficult. And the published data is intentionally misleading. So if you drop out of school in the 10th grade, you don't exist in the denominator in the 12th grade. You got that? So you actually can't, so you don't do a longitudinal tracking of students, you can't actually figure out what happened. And they used a really brilliant researcher, Chris Swanson, and he came up with a clever algorithm that generated an effective dropout rate. No one's taken issue with his algorithm. And he published data for the 50 largest school districts in the country. Everybody sort of guesses the results, but here they are. Over half of the black kids are failed by their schools and do not graduate from high school. That's the answer. So, you know, if you looked at the actual data of the schools, it probably says 65%. But in fact, if you look at who entered in the 10th grade and then who didn't graduate in the 12th grade, right, half the kids are failed. Half the kids are failed. In some cities, Baltimore, it's 2/3 of the kids. It's 2/3 of the kids. And he does it city by city, 50 cities. What happens to kids that don't have the educational skills, proficiency in reading and writing, to function in our economy? You all know the answer. There are no jobs for them at all. At all. Education affects housing, affects employment, affects tax base. With respect to the crisis in education itself, the consequences are extreme. Quality education is today essential in a way that it just wasn't 50 years ago. If you didn't graduate from high school in 1950, you could go get a good job in Detroit working on a car assembly plant, they trained you. And you'd put your kids through college and they did just fine. You'd buy a home in Detroit, worked out just fine. Can't do that today. Those jobs are gone. Half the kids are failed by their schools. So, what happens to those kids that are failed by our public education system? What actually happens to them? And the answer is they are literally acquired by the criminal justice system. Literally acquired by the criminal justice system. Some may have been engaged in criminal activity, but most weren't. They got stopped, they got picked up, they pled out because that was the quickest way to get out of the lockup, and now they have a record. And when you have a record, that's the end of it. You know, that's a point of no return. No skills, no education, criminal record, oblivion. Okay, here's a terrifying data point. For the generation of black people born 1965 to 1969, some of the parents of some of you here and some of you here today, for that generation, black men in that generation that did not finish high school, right? We're going to talk about the black men who did not finish high school. By the time they were 35, that would be 1999, so this is a retrospective data point, we're not guessing, 58.9% will have been in prison at some point of time. I'm going to say it again. If they did not graduate from high school, by the time they were 35, 58.9% will have been incarcerated at some point in time. Astounding. What happens? They are acquired by the criminal justice system. These realities have democracy consequences. They can lead to the moral underpinning of our ability to see each other as peers. You know, the reason those images that I mentioned have vibrancy is that this is what is evoked. If you don't see each other as peers, I think it is catastrophic for the aspirations of a democracy. The other categories, I think they can be just as easily analyzed. Housing, I just went over housing patterns, white flight from our cities, and the related problems we see in education. But you've spent a lot of time at this conference talking about subprime mortgages and foreclosure crisis that clearly disproportionately affects black and Latino families. It's devastating. Employment. I think we now all know, because it's now widely reported, that whatever the effective employment rate, it's twice that for Black and Latino populations. That's sort of the commonplace. And it may be even higher than that. Okay, if the effective unemployment rate, I think today it is 17%, then it's 35. Criminal justice. All right, that terrifying data point, I think, is all I need to say, but since Dalton's here, you just have to point out that of the enormous number of people that we have in prison in this country, 1/2 are Black and Latino. And what we also know from very sophisticated surveys is criminal activity distributes itself pretty evenly across our population. Okay? So if you survey the population, the participation in criminal activity, drug use, for example, is quite even, and in fact, white populations have more illegal activity than non-white populations. The point is, who ends up being prosecuted and imprisoned for it? And that is disproportionate to an unbelievable extent. If we went back 40 years, that disproportionality drops out. Okay, we did this to ourselves. The war on crime did this to us. Okay?